Your Honors, my name is Barney Given and I represent the appellant Matt Martorello. The underlying case which brings us to this court again today involves certain consumer loans that this court already determined were made on the reservation by arms of the Lac View Desert Band of Lake Superior Chippewa Indians under the breakthrough factors. By continuing the case, the appellees impermissibly seek to extend federally preempted state regulatory laws to Mr. Martorello, given that those laws may not infringe on the LVD tribe because they seek to regulate their making of loans on their reservation. Over 3 years ago, this court reviewed a very substantial record and adjudicated the servicing agreements, the loan and security agreements and promissory note, and the other corporate documents at issue in this case. It made several conclusions, including that the real party in interest, as this court typically calls it, or the rent-a tribe, as the appellees like to recharacterize it, is that big picture loans, which is controlled by the tribe and managed day to day by certain members of its tribal council, and directed the trial court to dismiss big picture loans and another entity that is the arm of the tribe, Ascension Technologies. In issuing this mandate, the court sought to protect the tribe's ability to govern itself according to its own laws.
Since the last opinion in this case, am I correct that the plaintiffs have entered into a settlement with Big Picture and Ascension?
That's correct, Your Honor. The settlement, however, came many, many months after the mandate, and there were other matters that were heard subsequent to the mandate. They should never have been heard.
Those plaintiffs are
yes.
correct the same question to opposing counsel. But as far as those plaintiffs are concerned, they have no further claims against either Big Picture or Ascension.
That's correct.
When the mandate went to the district court, well, what took so long? Why didn't the district court follow what we said? Do you know?
We don't know. That's the problem. We had urged the district court to do something, and in fact, it then held additional hearings. We don't know why the district court didn't issue the mandate, and that, in fact, was raised in our objection to the settlement, which was approved over our objection. And further, the settlement requires the tribal entities to continue making loans from the very agreements which they are now seeking to call usurious and hold my client liable for.
Mr. Given, I'm sorry. You said that the settlement was approved over your objection?
Correct.
How could that be? I mean, don't you have to consent to a settlement agreement?
Apparently not, according to Judge Payne.
So it was signed. I mean, it was a one-sided.
Yes. We weren't consulted. We didn't consent to it. We weren't a party to the settlement, but it absolutely affected our rights. We were the co-defendants. It should never have been signed.
I get it. I'm sorry, but certainly the entities, Ascension and Big Picture, agreed to the settlement.
Right. The tribal entities agreed to the settlement.
Okay. Sorry. I misunderstood.
No.
But in terms of the court not going forward with what we told the court to do clearly,
yes,
plain English, it didn't do it, did it?
Correct. It didn't do it until almost 7 months after the mandate, and it only did it in connection with the settlement.
So you knew what your remedy was, right?
Well, our remedy was to object to the settlement.
No, it wasn't. The remedy was to file for a mandamus.
Right. And I apologize. I was not counsel at that time, and I agree mandamus would have been an appropriate remedy as well. I don't disagree with that.
And the court scheduled evidentiary hearings, right?
Not on the settlement. There was
no before the settlement. I mean, before the settlement.
It did.
Right.
It did.
Well, who were the parties to that?
To the settlement?
To the evidentiary hearings.
Well, that would have been my client, the tribes, affiliated entities.
It took evidence and then said, I'm incorporating this into the record. Making it part of the record, did it not?
It did. It did. In those hearings, there were a couple of different hearings that took place after the mandate and before the settlement was approved.
Right.
Well, were Big Picture and Ascension part of those hearings?
They were.
And it should have been out of the case by the time,
Correct.
which we clearly said.
Correct. But again, I didn't represent and have never represented the tribal entities. Shall I continue? Thank you, Your Honors. None of the contracts that were issued in the prior hearing have changed, and there was no basis to re-adjudicate those same contracts. In fact, the questions already resolved pertain not to Mr. Martorello, but to the tribe. It is not his sovereignty to rent out, and he did not pass the more than 264 resolutions of tribal council related to how their lending business would work. Mr. Martorello has virtually no information regarding the borrowers and never had any contact with the borrowers.
The district court says its opinion that a number of the factual bases upon which its prior opinion and our prior opinion were based were obtained, for lack of a better word, fraud.
In Your Honor, we absolutely disagree with that. That was one of the hearings. It was a misrepresentation hearing that we disagree with those findings completely. And in fact, matters relating to that fraud are right now the subject of a pending motion back in the district court, because they all revolve around the declaration of a Ms. Joette Pete, who gave testimony in her declaration drafted by her counsel that was completely inconsistent with her deposition.
What does an appellate court do if its prior decision is later shown to be based on misrepresentation and fraud?
Because that decision itself also will be, obviously, we're here on an interlocutory appeal. That would be the subject of.
The question I asked was more generic.
I think, again, the court can look at the fact, I think, given the fact that even if you're applying a clearly erroneous standard, the judge was clearly erroneous. He ignored all of the breakthrough factors. He took evidence in that he shouldn't have. We think it was completely in error. If you look at how the judge got there, and the whole basis of the case, frankly, from day one, the way the rulings have gone down, there simply was not evidence of fraud, and the finding by the judge, we believe, was clearly erroneous based on his failure to apply the breakthrough factors. He just substituted a fraud finding instead. Oh, there's misrepresentation, but he didn't apply the breakthrough factors to the analysis.
In fact, am I correct that 28J letter came before we ruled in this case, didn't it not? Some of the information alleging misrepresentation wasn't it filed before our opinion issued?
Correct, and it was never
done that ourselves.
Pardon?
I said we could have done that ourselves if we felt that was that important.
But it was never raised. My understanding, I didn't do the initial appeal. My understanding, that issue was not raised before this court the first time it could have been.
Right, exactly my point to Judge Agee's question to you, and that is this court could have done something because some of those facts were alleged before our opinion issued.
But my understanding is that the appellees in this case, the plaintiffs in the underlying case, never raised that issue to this court's attention.
Exactly, right. I mean, so
it wasn't something, we don't have like raised judicata or collateral estoppel on the fraud issue. It was never raised to this court in the first instance.
Seems like a case where we handle the appeal and then it goes back to district court to try the case again in part because these issues could have been raised. I mean, in other words, there would be no issue preclusion at all. If you go back and you can do it in district court.
Correct, but they weren't raised before this court the first time, and that's one of the additional problems.
I agree with you, but let's go ahead.
Mr. Given, can I ask a follow-up with respect to this
Yes.
mandate issue? So I think you get that there's concern about the district court's not timely in enforcing the mandate of the court. But even if the district court had immediately dismissed the entities, there would have been nothing to prevent the court from proceeding with respect to the remaining defendants, right?
That's where we disagree, because then you have an impermissible party problem. Because again, what they're basically asking the court to do here is say, we're co-defendants in the trial case together. And the only way liability gets down to my client is if the loans that the tribe made on its own reservation were illegal under Virginia state law. In other words, we're like secondary defendants, so to speak, on a waterfall basis. But when the tribe's out, they're an indispensable party, which was one of our objections to the settlement. And now we're left to essentially defend the tribal lending practice. That's the problem. And the court, and we've raised that issue with the court, and the court disagreed. But I think clearly the tribe was an indispensable party once they were dismissed for us to go forward. And as the court's probably aware, it's extremely difficult to get discovery from the tribe. That's a whole nother process through the tribal council, but we weren't a party to the settlement. And again, we certainly were negatively affected by the settlement. And that's a long answer, and I apologize, but it really then goes to indispensable party.
But are you saying then the district court could not proceed it against Mr. Martorello without keeping the entities in the litigation?
Yes, that's our position.
Well, that suggests that, okay. All right, go ahead.
And it was raised in connection with the settlement and overruled. All our objections were overruled. And again, one of the other issues.
Is that an argument that you've made on brief here?
We didn't raise the indispensable party issue. We were really focusing on the mandate. I was simply trying to answer the court's question. Yes. But I want to focus, Your Honors, and I think in response to these questions, they're also asking this panel to ignore this court's rulings. There's three specific conclusions that I think are important that they're now asking to be essentially tossed out with the bathwater. One was that the tribe created big picture and ascension under tribal law for its own benefit and are indeed serve the essential self-government needs. That big picture is the lender and ascension provided the services, and more importantly, that the tribe controlled and owned big picture and rejected that the servicing agreements that my client had entered into were constituted control over the tribe. And that's again why all this is one unfortunately interrelated matter is we never had control over the day-to-day lending operations. If we don't have control over the day-to-day lending operations, we cannot be liable for any sort of tort with respect to the consumer loans that were being made. So again, unless this court finds a reason to vacate the prior findings, that was this court's, not Judge Payne's. That was this court that made those findings. And we're asking that those be upheld, reinstated. And I see I'm almost out of time on my initial. I can answer any questions the panel may have, and I'll have rebuttal time.
Yeah, sure. Thank you.
Thank you.
Wesley.
Thank you. May it please the court, Matthew Wester for the appellees. I think it might make sense to just pick up on maybe where Judge Diaz, you just left off, which was a question about what practical impact this several month delay in dismissing out the tribal defendants had on the rest of the proceedings in this case. Because Judge Diaz, I think you're right, which is whether that dismissal happened at 2 weeks after the mandate or 3 months after the mandate, it doesn't matter for purposes of this appeal, because regardless of when those tribal defendants were dismissed out of the case, consistent with the court's remand, the case absolutely could have and would have proceeded against Mr. Martorello alone.
The items that were presented in the district court that Judge Payne made his findings on that we have here, what was the prohibition on presenting those in the first trial?
I'm sorry.
Why weren't those presented earlier?
The issues? Is that what your question is? Why the issues weren't presented? The facts, yes. Yes. Yes.
She made these subsequent findings.
Correct.
So my question is, why was that evidence?
The discussion, sure.
Not earlier.
Yep. So the discovery that led to the misrepresentation hearing didn't come out until later, but it didn't come out in this case. There were multiple other proceedings pending while this case was up on appeal and before this court the first time against the tribe, big picture, ascension, and the individual tribal defendants, not related to this proceeding. And in those cases, additional discovery came out that made clear that some of the initial representations statements made by Mr. Martorello about his control over these companies were false. And it was only after that discovery and the related proceedings came out that Judge Payne reopened the proceeding to allow for this additional evidentiary hearing.
Under that theory, then that would turn finality on his head. You'll never have an end to the case. We make a ruling in appellate court with the record before us, and then in some other jurisdiction, someplace else in America, there's discovery going on. Oh, well, you know what? We need to now upgrade this and go on the remand rather than follow what we said on this court's clear remand. And then you get a chance to put that into the record. And then we say, oh, we got a new case here. Because who asked for the evidentiary hearing?
The plaintiffs asked for the evidentiary hearing.
You asked for it.
Yes, Your Honor.
And you knew that the parties that should have been dismissed at the time, should have been out of the case, right?
We're going to be out of the case, yes.
Right. You did it purposely to try to keep them in, didn't you?
Oh, I don't think so at all. And I don't think the record bears that out at all.
Why would so you're saying that everything that came out was only as to the defendant here, the appellant here today?
Yes, I mean, the evidence was focused on Mr. Martorello's role in the creation and then operation of this lending enterprise. It doesn't have anything to do with the tribe. I do want to
discovery come out. You have us as officer of the court. Can you tell us the date of the discovery in those other cases?
I can't, Your Honor. I'm happy to,
because you're representing that was the basis for it, and you make an allegation like this, officer of the court.
We'd be happy to provide the court. I'd be happy to provide
today, because this is very odd that we had set as an appellate court, and then you come back from the district court and say, "Oh, I found some discovery someplace else," and that's why our mandate was not followed for 7 months.
Right. So if I could make a couple points about the mandate, because I do think there's a difference between what is actually the effect of the mandate. I don't agree that the mandate controls or freezes into place the facts that the court took as a given when it issued its legal ruling in this appeal. This court's decision in Cortel, for instance, I think draws a very clear distinction between, the legal issue that a court decides on appeal and the facts that it relies on. The facts can change, just like if the court were reviewing a summary judgment motion, it made some legal conclusions. The facts after that decision could nevertheless change, and that would not violate the mandate rule in any way. What we have here is, I think, the same thing. The only question that this court decided, and the defendants themselves made this clear in their briefing to this court in the first appeal, as did we, was whether arm of the tribe sovereign immunity applies to these two tribal entities. That's the only question, and that was a legal question. But this court took as a given, it accepted the district court findings of fact for purposes of applying those facts to a legal inquiry, which is this breakthrough factor framework. But that doesn't mean that all of a sudden, whatever facts the district court found at the beginning, or which this court accepted as true for purposes of its decision on a legal question, it doesn't mean that those facts are frozen in place forever in time for the rest of the proceeding. This case wasn't final. It wasn't a situation where there was a final judgment and all of a sudden someone's invoking Rule 60 to come back and attempt to relitigate the case. Mr. Martorello was in the case from the beginning, is in the case now, and nothing has changed with respect to him, other than that the district court held additional evidentiary hearings to determine exactly what was mistaken.
Your client got the advantage of that, didn't it, for the settlement? You got a settlement against somebody who should have been dismissed from the case immediately.
I don't think that's
right.
No, I don't think that's right, Your Honor.
Didn't you get a settlement?
There was a settlement, absolutely.
You don't think that was favorable to your client?
I think a settlement is favorable to both sides of the equation. Mr. Martorello
had already won.
No, I don't agree with that, Your Honor. Because
wait a minute.
Yes.
You don't agree that we said in the mandate the case is dismissed against them and they didn't win?
I understand.
Now answer that question. Are you telling me they didn't win?
They won that issue in this case, Your Honor, but they were.
What was this an issue, or was it they were dismissed as a party? Which one?
They were dismissed as a party.
Okay, tell me why that is not a win. That's plain common sense, not law. Common sense. Tell me why they did not win when they were dismissed as a party. That's what I want you to answer that question.
They were involved in other proceedings.
Where?
in the federal court in Virginia, multiple other
In this
proceedings.
case?
No, two separate cases.
In this case, I can't, you want us to litigate the discovery over here, another case pending? I'm talking about this case. They won,
Yes, this
and
case,
they were entitled to have the mandate issued and dismissed, correct?
yes,
And 7 months later, you got a settlement.
yes. Yes.
Okay, go ahead.
Thank you. If I could just return back to what I think is the key question for this panel in this case, which is regardless of the delay that may have occurred between when this court issued its decision and when those defendants were dismissed out, it does not affect what is at issue in this appeal right now. The only question is whether the class certification order that the district court issued is whether it abused its discretion in some way, whether there were predominance issues in the case that affect its analysis of the Rule 23 factors, or whether Mr. Martorello can enforce one of these tribal arbitration contracts. Those are the issues that are in front of this court today. You heard Mr. Martorello's counsel say in response to your question, Judge Diaz, what would have changed? And he said, well, there would have been indispensable parties. Well, they made that argument and they lost, and they have not appealed that issue. So right now, what you've got is a class certification order in which the district court went through the factors thoroughly, and there is nothing about that decision.
Is it your view that the class certification order is completely divorced from the district court called its misrepresentation order, that the findings in that order are unnecessary for the class certification?
That's correct, Your Honor. There are only two grounds other than the tribal arbitration contract issue, which we haven't talked about. But beyond, if you set that aside, there are only two grounds that Mr. Martorello argues should have defeated class certification in this case. Both of them are related to predominance, and they relate to his role in the case. He argues that he had a decreased role over time, and he argues that there's no way to trace the money that came through this enterprise to him. That's it. Those are the two issues, other than arguing, again, that the contract allows him to avoid class actions. But even if you accept everything that he says today, that he didn't have as big a role in this, or wasn't involved in its creation at the beginning, neither of those two issues affects predominance. The focus of Rule 23 predominance inquiry are in the elements of the plaintiff's claims, which are, in this case, RICO claims and state law usury claims. And nothing about a defendant's role, whether that in fact leads to liability or not, affects what the district court said about how all of the elements in this case are common to the class. And more than that, even if you think that there is some predominance issue, or there may be a reason why you should accept what Mr. Martorello's counsel has said about I'm sorry, my time seems to have.
You have time.
I don't see it. I apologize. The clock doesn't seem to be on.
That may be to your.
Oh, I'm sorry. My apologies. My apologies. Even if you accept that his theory about the class here, that he had a decreased role over time, or you accept that there is a traceability issue with respect to how you can apportion liability. Those two issues are themselves common to the class. So they don't at all impact the district court's predominance analysis.
So if we agreed with you, the class certification is appropriate. Proceeding on the merits would go forward with the factual basis that was in the district court's second opinion. Is that right?
Yes, I think that would be right. And
And at some point there would be an appeal, I assume, unless there's another settlement. And the issue would come back here, would it not, on the mandate?
It might, Your Honor.
If a verdict on the merits was based in some part on that evidence.
I think that would be right, Your Honor.
So in the mandate sphere, appellate courts would usually be bound, and obviously the district court would be bound. But there are exceptions. One would be where there's new evidence that wasn't previously obtainable with the exercise of due diligence, or the other one would be where there is a blatant error that would amount to serious injustice. So which do you say applies in this case?
But I think it would be new evidence. If I could just have a little 30 seconds to provide some context to that answer, though, because I want to emphasize that the mandate here did not find facts. It accepted the facts as the district court found them in the original set of proceedings in this case. And so I don't think under this court's mandate rule doctrine, which is just a specialized version of law of the case, that it could operate to bind a district court in future proceedings based on the record as it existed at the time of its initial decision. That might be different if this court's decision in some way found facts or rejected a series of factual findings by the district court, but that did not happen here. The only question at issue in front of this court in the first proceeding was a legal one, which is just whether arm of the tribe immunity applied to these two entities. But that has nothing to do at all with what happened later. Even if you, Judge Gregory, agree that there was too much of a delay that led to the dismissal of the tribe's companies, it doesn't freeze in place for all time the way the record looked when this court first decided its case. If that were true, then any decision on summary judgment or even an earlier one, interlocutory, that had a fact section in the opinion would restrict a district court's ability to conduct future findings. Now, if you think, Judge Agee, as you suggested, that there was some problem with the way that
I'm just asking.
I understand, but if any of the on the panel think that that would be true, there is going to be a later point in this process in which the defendant, Mr. Martorella, will have an opportunity to make that argument. But the only thing at issue in front of this court now.
The second district court proceeding was the argument raised below an objection to additional findings of fact that there had not been an exercise of due diligence. Was that argued and heard?
I don't believe so, but I could be mistaken. My friend is nodding his head. I'm sure he can clarify. I was not involved in the proceedings below, but it may have been true that there was an objection from someone in the proceeding, in which case they could either have preserved that objection and raise it later, or they didn't raise it here and it's waived. But it isn't in front of this court on this record, on the order that is the subject of this appeal. And I think that's significant because as a matter of appellate jurisdiction, this court is limited to reviewing the only order that is in front of the court, and that order does not take into account in any meaningful way any of the misrepresentations that the district court identified as being made by Mr. Martorella. It asked only whether the Rule 23 factors had been met. And there has been almost no effort by Mr. Martorella to contest those conclusions other than the two grounds that I identified earlier. The first, which was this idea that traceability can somehow affect predominance. There's no authority at all, and Mr. Martorella has cited none to support this idea that dollars, that you actually have to trace dollars anywhere, or that it can affect predominance under a district court's Rule 23B analysis. And his argument that he had a decreased role over time, again, which was partly the subject of the misrepresentation hearing. But even if you accept everything that he's saying is the correct way to understand the facts, which I think would be incorrect based on the clear error standard, it doesn't affect predominance because it is first an issue that is capable of being resolved on a class-wide basis. And it's about his liability, not about the elements of the claim.
Mr. Wessler, of course, we don't even get to this class action analysis if we find that the loan agreement is in fact enforceable. And so I think we should probably talk about that, because it strikes me that this agreement falls somewhere in the middle between those agreements that we have found to be blatantly unenforceable and an agreement that at least one district court suggested might be enforceable because it made more than a passing nod to the applicability of federal law. So why isn't this agreement closer to that than the others?
Sure. So a couple responses to that, Judge Diaz. First, I think this agreement collectively is worse than several of the other contracts that this court has invalidated, and I'll explain why. if you look here, the alternative dispute resolution system that is created by the contract. Now, just to step back for 1 second, the question in all of these cases is whether the choice of law clause that selects tribal law and the choice of forum clause, which selects some version of arbitration, together in tandem creates a prospective waiver that prevents a borrower from effectively vindicating their rights. The alternative dispute resolution system that this contract creates, unlike all of the others in Hayes and Gingras and Haynes and Hengel, it completely eliminates any AAA or JAMS participation in the process. In all of those other ones, at least the contract said you get to go to AAA or JAMS to resolve your disputes. Here, it's an entirely insulated process created by the tribe. It does not permit the appointment of any neutral outside arbitrator, which those other contracts did. Instead, it permits the tribe to select a decision maker. It doesn't put any guidelines or restrictions on who that can be. It could be the sibling of someone who works for one of these companies. And it mandates that that system is the sole and exclusive method for resolving all the disputes that a borrower may have. Now, you asked a question about this language that appears to reference applicable federal laws in the contract. The contract in Haynes and in Sequoia both included a similar phrase in the contracts. And what this court said was that's insufficient to somehow get you out of this box that these contracts place you in. It's insufficient for several reasons. The first is it doesn't specify what applicable federal law ever means. It is also
all, doesn't it? Wouldn't it?
I don't think so. And the reason it doesn't.
Did it exclude any?
Yes. So what it says.
What federal law did it exclude?
So if you go to the code, which is the basis for any claim under this contract, the code includes references to a number of federal laws. Okay, so it's applicable federal law, and the code says here are the laws that apply. But what's missing from that set of laws are the laws that are at issue in this case. So this is the same that was true in Haynes and Sequoia.
You think that's intended to be exclusive?
Yes, and I'll tell you why. Because in the contract, elsewhere in the contract, no different from any of these others, the language says that all of the disputes will be, and I'm quoting, subject solely and exclusively to tribal law. And so that language, as this court has held, as the Second Circuit has held, as the Third Circuit has held, trumps any effort to try to avoid an interpretation that would be irreconcilable between those two clauses to somehow breathe life into this idea that all federal laws are now somehow back on the table.
Never been back on the table. They're written in the contract. They're written in the contract. It says all applicable law.
It doesn't say all applicable law, Your Honor.
What does it say?
It says, I can get you the actual language. It says, we'll be governed by the laws. I'm paraphrasing because the tribe's name is long. We'll be governed by the laws of the tribe, including but not limited to the code as well as applicable law. And so what courts have said that as well as applicable law, as well as applicable federal law. I'm sorry, I missed.
Thank you.
I'm sorry, I missed the key word.
You did.
Yes, and I see I'm out of time. Can I respond?
Yeah, please respond.
So that language was also in the contract at issue in Sequoia and Haynes. And it was also in the contract at issue in the Second Circuit's decision in Gingras. And what all of the courts have said in that context is it's not actually clear what applicable law means without further definition. But all of these contracts require that your claims are those that are provided available to you under the code, and the code invokes the relevant federal laws that apply. And the laws that are at issue in this case, just like the laws that were at issue in Haynes and Hengel and Gingras, they are not included in the code's invocation of the relevant laws. And so the absence of the specific laws that a borrower is seeking to pursue, the absence of those laws in the code means that the contract cannot be interpreted to somehow permit a borrower to pursue any or every federal statutory cause of action that they have.
And of course, because it seems like this applies a lot when it's a tribal type loaning, but all other arbitration agreements you're saying that occur all in this country every day, that they're wrong if they don't say list every specific law that applies to it. They can't just say all laws in the United States or federal law. They held to that standard too?
Judge Gregory, they don't do that.
No, they don't do it. Why should they do it here?
They don't do it for a very specific reason, which is because that would waive their sovereign immunity right. They can't accept that all federal laws would apply to them or in a proceeding, because they assert that they are immune from any claim brought against them under any law that they haven't either themselves waived their sovereign immunity for, or for which Congress has waived their sovereign immunity. That's why these contracts have created this problem.
The sovereignty has been upheld by the courts, right?
The sovereignty has, Your Honor, but not the use of that sovereignty to waive borrowers' rights under the contract. And so those are two different things. Yes, someone who is legitimately operating as part of a tribe is entitled to sovereign immunity, but that doesn't mean that a contract that deploys that sovereign immunity, as this court in Hayes put it, to surreptitiously waive borrowers' rights, even against non-tribal members, which is what we've got here, is somehow enforceable under either the Federal Arbitration Act or as a matter of public policy. I see that my time has expired, unless the court has any further questions.
I don't, thank you.
Well, thank you, Mr. Wexler.
I'm going to lean over this way a little bit. I apologize because I've got notes and they relate directly. I think the court hit the nail on the head. This is a different circumstance because it was the application of tribal law and all applicable federal law. And in fact, the tribal dispute resolution process in the document itself says that borrowers can bring federal law claims. What the borrowers chose to do was completely ignore the tribal dispute resolution process, which would have served as a gatekeeping function, and go directly to federal court. The cases that are cited, and we pointed this out in our brief, the cases that are cited by the appellees all involved matters where they were trying to eliminate federal law as opposed to a state law, federal law confluence. And we pointed out in our reply why the cases are distinguishable.
Notwithstanding that language, when the case is determined either in the resolution process or if it went to a tribal court, what requirement is there that they actually follow federal?
Well,
isn't the tribal law the supreme and only authority here?
Well, we believe that as a first cut, yes, that probably would be, but we didn't even foreclose that right. In other words, the tribe said you can still bring a federal action. It basically the resolution process is where we're engaged discussion. Well, it just says other applicable federal law, and it says in the tribal dispute resolution process that they can bring federal claims. It doesn't specify what they are. I would like to I do need to rebut one thing though that's very important here.
Let me ask you this first, because the agreement says that it's subject solely and exclusively to the tribal law and the jurisdiction of the tribe, and it is the sole and exclusive authority for resolving disputes or claims arising from this agreement. So how do you get to federal court from there?
Well, because it says in another section that other applicable federal law it's applicable. And the reason I get there is, again, you've got to take the contracts as a whole. The tribal dispute resolution process.
That goes to my original
question.
Right. So it sounds like to me the language authorizes a party to raise a federal claim, but it doesn't obligate any of the tribal authorities to follow it.
That question, I don't know the answer to that. I'm going to be candid with the court. I'm not sure the interplay because we haven't, that issue hasn't been litigated. I would like, though, in my limited time, just to go back to the issue again, is that the only way we got to these alleged new evidence, and we alleged there was no new evidence. It was basically a declaration of Ms. Pete that was put in, but keep in mind, they undertook discovery involving the tribe after the mandate was issued. That never should have happened in the first place. So basically, it creates this never-ending universe of new facts and new law, and they're obviously in a favorable court where you're going to be in a situation, oh, go take evidence. They should have been dismissed with prejudice immediately. That issue was raised, they weren't dismissed, and that now put my client in a very tenuous position.
But how would that have prevented them from taking evidence against a non-party, even if they had been dismissed?
Well, they could have taken evidence against a non-party, but they took it as a party discovery. And again, that's also a different protocol. But yes, they could have taken, they could have entertained discovery against the then defendants. But again, that in and of itself, having the defendants in the case was improper. And again, the only basis, you have to find new evidence, and there was no new evidence to justify ignoring this court's findings. What counsel argues is almost circular. They're saying, in the first opinion, you just affirmed Judge Payne's findings, and, you know, so that was fine, but they didn't allege in the first appeal that Judge Payne's findings, the findings that they're now contesting, were in error. They're saying, oh, we're going to kind of lay behind the log, let those go up. The appellate court confirms that it goes back down. Now we're going to go back to Judge Payne, reopen the case, reopen evidence, and now we have this new evidence, and all of a sudden there's a misrepresentation which completely alters the scope of this case. And I did want to make mention, because I've heard counsel say this is the issue or that's the issue. There are three discrete issues which are before the court today, and they're in the briefing, and I know we have limited time, but mandate was one, predominance was the other, and the third is the waiver doctrine. But again, I think if you look at our case law, because these loans are different, the loans in the other cases, for example, like the cash call cases, that was where the non-tribal defendant purchased loans from the tribe and then collected on those loans. There's no factual dispute here anywhere in the record that Mr. Martorello either originated the loans in question, serviced the loans in question, or collected on the loans in question. That's what distinguishes the facts of this case from the other cases cited by the appellees, where there was a finding of a waiver doctrine because of the nature of the underlying contracts themselves. See, I'm out of time. Does the court have any additional questions? Thank you for your time, Your Honors.
Thank you, Mr. Given, and thank you, Mr. Wessler. Thank you for your assistance in this case. We can't come down and greet you, but know that we appreciate your presence and we wish you well. Thank you so much. We'll proceed to our next case.
Your Honor.
Toma, you may proceed.
Thank you, Your Honor. Good morning, and may it please the court. There's no dispute in this case that the traffic stop was extended after the officer printed the warning citation at 11:59. The only issue for this court to resolve is whether he had reasonable suspicion to do that. The district court found reasonable suspicion based on just two things: that the driver was purportedly slow to stop and that she was excessively nervous. Neither of these conclusions are corroborated or supported by the officer's own video footage. It makes sense that the government is opposing our pending motion to supplement the appendix with the video from the dash cam. The video of the officer's body cam was supplemented in appendix already. Both are part of the record. But if this court watches the first minute of that dash cam video, I think it will clearly see that the driver was not slow to stop. And in fact, she pulled over at the first available opportunity to her. Alternatively, if
there's nothing in the videos that's not in the record, because I know I've seen several videos.
That's right. Both videos are part of the record. We were simply attempting to
This
supplement the
isn't- yeah.
appendix. So the court can view it either way if it has it. Alternatively, it could judicially notice a map of the area, which it could do and has done before. And the address for the First United Bank is 1951 Hunters Way, Morgantown, West Virginia 26505. Either way, consulting either of those sources, what this court will plainly see is that the driver of the Jeep, Ms. Phillips, was at the moment when Officer Helms activated his lights to pull her over, she was already past any reasonable opportunity to take the turn he said it was suspicious she did not take. It will see that at 30 seconds into that dash cam video, the Jeep and the dotted line to enter into the turning lane for the Hunters Way parking lot, as he calls it, which is actually Sterling Drive, was neck and neck, was even with the dotted line. And that in order for her to actually take that turn at the moment he activated his lights, she would have had to cross a solid line to do it. She would have had to violate a traffic law. This court will also see, if it consults a map of the area, that the driver took the very next street to turn over. She did it within 17 seconds, and it was the only next turn available to her. And it will also see that there is no shoulder on the section of road between those two streets. And for that reason, the evidence is important because it explains and confirms why the district court's reliance on the distance, the 50 to 70 yards, or the 17 seconds it's nonsensical because it was the first opportunity. Secondly, in terms of the nervousness, I think if this court watches the video, it can also see that the driver is not excessively nervous. This court has before refused to accept factual findings that are contradicted by video footage, and it can do so again here too, and it should. We have cited on page 3 of our motion to supplement the appendix United States versus Kehoe, and also Scott v. Harris, in which the Supreme Court found that it was erroneous for the district court to make findings that were contrary to the video evidence. We would also point this court to United States versus McGee, 736 F 3rd 263 at 270, which is a 2013 case, that says that even credibility findings by the district court are not insulated from review if the documents or objective evidence contradicts that testimony. And also, of course, it was relevant in Bowman that although the officer cited nervousness, Bowman appeared and sounded calm in the video. But I also want to say that—
Summer, can I just take you back to what you just said earlier about how long it took for your client to actually pull over? The district court in her order indicated that the officer's suspicions and concerns were heightened for officer safety. That was the concern, that pulling over into a darkly lit part of the highway, that she was slow to pull over, pass at least one or two well-lit streets and parking lots in favor of a dimly lit section of the route. So what part of that do you take offense to?
Two offenses I take to that. The first is that another reason why the dash cam footage is so important is because if this court watches, again, the first 30 seconds, it will see Officer Helms pass by several bigger and more well-lit parking lots without activating his lights or making any attempt to do it. He does not turn on his lights until 30 seconds in, where he has allowed the vehicle to drive into a darker area of that stretch. That cannot be attributed to the driver. That can only be attributed to the officer. And again, it's a reason why I think the dash cam footage is important to watch, at least the first minute of it.
And the other thing that the district court judge says is that it may not seem like 17 seconds is a long time, but it's some math, which is always a precarious thing for lawyers and judges to do, and indicated that the car might have traveled at least 100 yards. And while that may not seem like an unreasonable amount of time, we shouldn't Monday morning quarterback the officer. And it's true. I mean, in most cases, particularly when we don't have the benefit of video evidence, we defer to the officers, to the district court's findings of fact. So what is it about that is problematic in your view?
Because again, I think if the court just looks at the first minute of the dash cam video and or consults a Google map and clicks over the satellite tab, you can see very clearly that distance or time notwithstanding, there is no other opportunity before she pulls over for her to do so. There just isn't one. She has no shoulder. There is no street between the two. It could have been a mile and that would still be true. But I would also point out that the actual distance is, according to Google Maps, it's 0.1 mile. It's very short. It is the very next block. I would also point out that in terms of officer safety, for all the reasons I've just explained, those circumstances were not the driver's choice. They were a necessary result of the officer's decisions and actions that evening.
And she didn't get to decide when he would turn his blue light on.
Correct. She could not.
And it's clear you can see when we have to guess on that, right? I saw both of them. She was driving. She's next to where he said she'd turn. Like I said, and if she had made a sharp right to try to get over it, I guess would have been another problem. Say, oh, you see how she made that sharp turn.
I believe she would have had to have crossed the solid line, in which case she would have committed a second traffic infraction.
Right.
Nonetheless, I just want to say that not all of this aside, those two factors alone, even if they were true, they aren't, but even if they are not enough to create reasonable suspicion. And I think it's notable that neither the district court nor the government has cited a precedential decision of this court finding that being slow to stop and nervous is reasonable suspicion absent anything else. And of course it isn't. I mean, this court has said over and over and over again that nervousness is not a good indicator because just about everyone is some level of nervous when pulled over or interacting with the police. In Bowman at 214, at Massenburg at 490, I mean, on and on and on. Also, even that aside, the behavior of the driver in this case was not really nervous. I think you can see from the video, but even if it was somewhat nervous, giving the absolute most benefit of the doubt, it's not extreme or unusually nervous as this court has required previously. For example, it was not accompanied by any heavy breathing or heavy sweating or pulsing arteries or shaking hands like in Mayo.
No furtive actions as well.
Nothing.
Avoiding the police officer's eye contact. None of that. I didn't see. I looked at it.
It's a very innocuous video. And, this court has also said that sometimes, a handshake is just a handshake. Sometimes things have ordinary explanations. And so for the district court to, and I think if, my reading of the district court's order is that the district court very clearly acknowledges that we cannot see any of these things the officer claims occurred. They're just not on the video. We can't see them, but the officer said that, we can't see any handshaking, but the officer said there was, so that must be true. And I think that's frankly dangerous because it gives officers the green light to simply know that they say certain magic words that we can't, they said it, so it must be true, even though our eyes are telling us something else. And I think for that reason, Judge Wynn explained in Drakeford that we really have to have rational limits to experience as a placeholder for objective facts, that even with his training and experience, Officer Helms fell short here of his duty to explain why what he observed didn't have some equally plausible, innocent explanation. Again, as in Drakeford, sometimes a handshake is just a handshake. Sometimes talkativeness is simply a personality. Sometimes nervousness is just because you've been pulled over the day that you got your valid learner's permit or license again, and you're driving your daughter's car. And maybe that wasn't how you saw your evening going. I mean,
One is it in terms of nervousness. I mean, it seems looking at it, I don't see how this would exclude 99% of the people who are stopped by a police officer.
it would not exclude a substantial portion of innocent travelers.
I hate to say that, having experience here, I think nervousness does come when you're stopped.
I would agree. So, and also notably, I mean, the district court at the time of its decision didn't have the benefit of Drakeford, which was issued afterward. So that may have played a part in it, but nonetheless, Drakeford, of course, is correct. All of this court's prior precedent that we've pointed out is correct. And there just simply is not reasonable suspicion in this case. I am happy to answer any further questions the court may have. Otherwise, I'll reserve the remainder of my time for rebuttal.
Oh, thank you. Ms. Wesley?
May it please the court. Officer Helms testified that he regularly parks his vehicle in the Smokers Friendly on Route 7, which is in Morgantown, West Virginia, because it's a well-traveled drug corridor between Monongahela County and Preston County. He further testified that from that vantage point, he can see traffic violations as they pass. He further testified that in 2018, he conducted approximately 280 to 300 traffic stops. A good bit of them occurred in that area. That makes him familiar with what people do when he executes a traffic stop on that Route 7 area. And his testimony is that Hunter's Way, which is a big parking area, which is well lit, is where people pull over. Now, he also testified.
What's that sign that people know if police come, make sure you pull over here?
Well, there's not a sign, but what makes sense is if you're a motorist, is that you want to pull over someplace that's safe. You want to pull over someplace where there's well-lit area where people can see you and you can see others. This car drove beyond the well-lit area, did not pull off the road, parked on the side of the road where it is dark, where it is dangerous as other cars are pulling off, and where Officer Helms.
The officer say at what point he routinely activates, or he always activates at the same point on the road?
What his testimony was.
Say that he always activates his blue light at the same point on the road.
His testimony was.
Yes or no?
It's not a yes or no answer, Your Honor. Well,
I ask you, did he testify that he activates his blue light at the same point every time in those 200 stops?
He did not testify to that.
No.
So the answer is no.
You can explain, but please just answer the question. No, go ahead.
His testimony was that there was another car between the vehicle that he was following and himself. And once that car moved out of the way, then he activated his lights.
But it made a difference here. That's the point. It made a difference, didn't it?
But when you look at the video, you can see the turning lane. Well, the turning lane where that vehicle still could have pulled in. And he also testified, you could have seen it. And
women. Yeah. Yes, it was physically possible? That's what you mean could have?
Yes.
Okay. What counsel didn't concede that. Yes, she could have pulled into a solid lane.
Well, and his testimony in addition to that is he had observed vehicles do just that, because that was his testimony, because that is where.
And so the motorist is put to the test that you have to have the same skills, reaction time as everybody else. And that if not, then that's probable cause to stop. You know, most people were able to maneuver that and make that stop there, but you didn't. And that's probable cause to stop the car and search?
No, the cause to stop the car was.
Of course, we know was the tail light.
It was.
But I'm talking about why we're here today is not about the tail light. We're here because that stop and her circumstance of when she stopped is the basis for saying only two, nervousness, and didn't stop at the point where, as you're now urging us to say, 200 people always go there.
That is the initial red flag that builds upon the circumstances.
Flag, if it is.
It's the first step. It was his first red flag that built upon his reasonable suspicion that there was criminal activity afoot.
Okay, what's the next?
The next one, Your Honor,
Oh, go ahead, Judge Agee.
I'm sorry.
My recollection of the video was that this area you're describing is basically parallel to the woman's vehicle at the time that the lights were activated. Is that accurate?
My recollection of the video is, Your Honor, you can see the turning lane where she could have turned off, and that wasn't what happened. When the lights were activated, there was an opportunity for her to pull off, and she chose not to. And so the officer's testimony is, I'm thinking either one, we're pulling off here for a variety of reasons. One, they're concealing something. Two, they're getting a story together and planning. Or three, for officer safety reasons.
In answer to Judge Agee's question, doesn't it show that she's nearly parallel to the place that's supposed to be the lighted place that people normally stop? Isn't that true?
No, it's not true.
So what video did you look?
The area, and part of the problem is that the video obviously does not depict this area. There's testimony about this area. It's a parking area, it's a parking center. So Route 7 goes through this corridor, and next to it, there are businesses and parking areas. That is the area that we're discussing here. So yes, she stayed on the main road where there is a big parking area from a business that is off this main road. The video obviously doesn't depict that. And I believe that Officer Helms was clear about describing that the video camera, as well as the body camera, whichever camera, did not fully depict the scene.
Well, I don't know that there's any dispute that the area was there. The question was whether at the time the officer turned on his lights, there was sufficient time for her to get there as opposed to where she ended up.
I believe from looking at the video that there was sufficient time to pull there, that she could have pulled off into that area. The next thing that occurred is when he approached her vehicle, and she's clearly shaking. His testimony was.
Really shaking?
His testimony was.
I'm not talking about. I don't have to rely on someone's testimony when I can see what happened. You said she's clearly shaking.
Well, Your Honor, that's the problem, is because his testimony was that the video did not capture.
I was looking at the lady's face. I mean, maybe I saw the wrong movie, because the one I saw, she's right there talking to him from the beginning, and you can see her talking to him. Oh, officer, she's getting there. That was a different person. You got another video?
Nope, not a different person.
Okay, go ahead.
So,
I'm worried now. Go ahead.
What his testimony was, that he always looks at the hands for safety reasons and because of firearms. And as he's watching her hands are visibly shaking. He further testified that that was not depicted on the video, but he had his flashlight and he clearly observed her shaking hand, which was shaking when she was reaching for the required material, driver's license, registration. And when she handed to him, it was shaking as well. It would be fundamentally.
I saw her handing. She went there. She was explaining she had been to DMV. I think I saw when she handed that to him. Was another document because he held it for a long time, was blocking the light. He was looking at it for the longest time through the light. It was an interesting type vision of it. I saw it when she handed that to him.
She handed it to him in his testimony. His unrefuted testimony, quite frankly, Your Honor, is that her hands were shaking. And I understand that.
The video showed her handing it.
And the testimony is. Sorry, I mean to talk over you, Your Honor.
I know you did. But does the video show her handing the document to him?
Yes, it does.
Then can I see, is it right when I said I saw that?
His testimony was that the video, which is not the best quality, does not accurately depict what he observed. It would be a profound mistake to conclude that if something is not observable on the video, that it did not happen. That was his testimony. There is no reason to conclude in any way that this officer testified falsely or was not honest about what he observed.
Well, it's saying that the question is that I give that the fact that she says she was drumming along the side of the door. You can't see that. I'm not talking about that. But you now want to include that she was shaking. You can see she was visibly shaking when she gave him the documents. That's what I'm talking about.
Well, that was his testimony in the record, Your Honor.
Okay.
That he observed her visibly shaking when she was retrieving the information and when when she handed him the information. And my recollection.
Sorry, I
Okay.
interrupt you, but even if we accept that, and of course, the problem is that the video might suggest otherwise. The question is whether or not the nervousness that he claims the officer testified to observing is beyond the norm that we would normally discount, right? That's the issue. And it just doesn't strike me as she was nervous. She responded to the officer's questions, perhaps a little bit too verbosely for his satisfaction, and she tapped on the window. So those three things, what is it about those three things that you say amount to the kind of nervousness that is probative to a question on a motion to suppress?
So Officer Helms testified that her behavior was beyond what would be nervous in the normal traffic stop.
Okay, okay, go ahead. Explain that. Why is that?
Well, of course, he's conducted thousands of these types of behaviors, and he actually said that it is typical for people to be nervous in the traffic stop. Her nervousness exceeded what normally occurs in a traffic stop. And as a result,
Did he explain why?
what he did is that he employed an interdiction type technique where you tried to calm them down to see if it changes. And that was the reason why he quickly said to her, to dispel her nervousness, I'm only going to issue you a citation if everything checks up. So he says this to her, employing this technique, and it did not change. Subsequent.
Okay, but didn't he at that point then go back to his car? So how could he have observed no difference in her nervousness?
Well, what he observed then was the nervous tapping on the door, which is an obvious exhibition of nervous behavior, to the point that when the other officer showed up, he uses as a training technique and pointed out and said, do you see what she's doing here? That tapping on the door. That is a classic sign of nervous behavior. That was after he made the attempt to dispel her and to calm her down, and it did not work, which is the reason why.
Let's assume that all that's accurate. She's nervous. Whether or not that's nervousness is in excess of the norm when someone stopped is debatable. She could have physically pulled over into a better lighted area, but went a little bit farther. What makes those two items sufficient to merit reasonable suspicion as a matter of law?
There are several things. First of all, one of the things that we can't do is discount Officer Helms' 14 plus years of experience, more than 2,000 traffic stops where he is engaging with individuals in this situation. And one of the things that he did was he clearly articulated why each thing that she did made him believe that this was not a normal traffic situation and that there was something else going on. You couple his experience and how diligently he wrapped up this whole situation. It was 8 minutes. It was 8 minutes from beginning to end. The K-9 is already in the car. The backup, as a matter of protocol, is coming to that location because that is what they always do. His experience, the indicators that he discussed, he calls it a slow roll. He knows what people typically do. That car did not do that. When he approaches the vehicle, the shaking hands, the nervous bantering about the DMV and her grandkids that was in no way responsive to the traffic stop. Him telling her at this point in time to calm her down, that I will just issue a warning citation if everything is okay. And it did not work. Rather than a sigh of relief, she engages in more nervous indicators, which is the whole tapping on the door.
The
Ne-
police said it had nothing to do with it. What does where is she going have to do with the stop?
It had nothing to do with the
But the
stop.
officer uses that, right? I mean, is that a technique?
That is a technique.
Right. Isn't that a technique that normally involves people being more nervous? Because first of all, you stop me. I'm going in the direction of the highway. I'm going east on this highway I'm going. Where I'm going is really not your business. The question is, why are you stopping me? But I know police officers do that because you're right. But that heightens your suspicion. First thing, where am I going? Well, you stopped me. Well, you asked me where am I going? But people don't do that. But that's the first, so you get nervous because you're saying it's more than just this. Because you're asking me about something that's really not your business. Right? Because that's what America is. That's why our founders were just so, they were radical. They said, you just can't do, that's why the Fourth Amendment is so powerful. This originalists should be joining these cases because they said, no, you can't do that. Why are you telling, I don't have to tell you anything. Sir, here's my registration and here's my license and that. But you don't because you try to be cooperative as she was. And then you're punished if you're trying to say, well, let me get to you. And I went to the DMV and I got those things. That's nervousness. That seems to be you're a criminal. You're doing something wrong. But she talked about her grandchildren. You said it as if that was like, who talks about their grandchildren? Well, I got some grandchildren. I might talk to them. I'm going to pick them up, for example. I'm going to pick them up. Like, why are you stopping me?
So one of the things that Officer Helm has that certainly most people don't have, in addition to his years of experience on the job, is training and education on detecting and deciphering these clues. And it would be a mistake to discount those things. There are classes on deceptive behavior. There are classes.
Let me say this about you. I agree with you. Officers have a lot of experience and they should use that experience and they do it to help people. I'm not discounting it at all. But the problem is this, you could do the same thing. There are some officers who, because of their experience, the way you answer the first question might put them on notice. You said, where are you going? It's your business where I'm going. Something like that, they answer like that. That might be a suspicion. But we couldn't, I don't think any court in America would say, it was probable cause to search them because the first response was, it is not your business where I'm going. Do you agree with that?
Well, I do agree.
Do you agree with that?
I do agree with that, but that's not what happened here.
I know it did, but you're saying intuition is important, but it is not sufficient. That's the question. I granted, officers might say, it's something about this. I just think, I don't know, because you're right. He was mumbling to somebody in there said, well, she's tapping, she's doing that. But that may arise your suspicion, but is that enough under the Fourth Amendment in our jurisprudence? That's the question.
In and of itself, it would not be enough, but it's not in and of itself. There are substantial other things that are going on that he articulated. When he goes back and he approaches her, the first thing when he asked her if there's anything illegal in the car, her comment was, not that I know of. And then she says,
well, that would be a good answer when you got two other people in the car, wouldn't it be?
Well, most people
I know of,
but most people do know what's in their car.
So you know what? I've had several people in my car once to go through their pockets before they sat in the car.
Well,
do you?
Yes, but remember, this is from.
You ask anything in the car, which would include anything that anybody has. She answered as correctly as you can. So not that I know of. In other words, I can't vouch for everything, but not that I know of. And what kind of jurisprudence? Your counsel, you're urging us to say the constitutional sufficiency is there because she answered, not that I know of. That's suspicious. She should have said no, right?
Her next statement was, not that I'm aware of. Then she says,
sorry, before you get, I'm sorry.
I'm sorry.
But is any of that relevant? Because did the district court actually find that relevant to its?
Well, no, you're right. The district court did not get there. The district court found that there was reasonable suspicion and that he was justified in the brief extension at that point.
But you want us to find additional facts?
think that these facts are part of the record.
Well, but had the purpose of the stop at that point been executed? Had he already given her the warning?
He had not given her the warning. Quite frankly, when you look at the video, she was not giving that warning ticket well into the traffic stop. She had not received her warning citation at this point.
Well, it came through, didn't it come out? You could see it roll out?
He started it, and then when the officer came, and he was instructing the officer about observing the nervous tap, then he went and he approached her, but he did not hand her that warning citation.
So he prolonged it at that point, didn't he? Because he didn't just snatch out and give it to her.
No, yes, I'm not certain if he had finished it, if he had to go back and finish it, but certainly, yes, he started it, he stopped it, and then he went to speak with her. But she did not get that citation until later. But the point of that is, not only did she say, I don't know if there's anything illegal in the car. She then clarifies and says, I don't have anything illegal in the car. My daughter doesn't have anything illegal in the car. My boyfriend doesn't have anything illegal in the car, and I can't speak to anyone else.
Yeah, but I think that all happened after the stop had been improperly extended, so.
Well, the whole stop before the K-9 was about 8 minutes. And so the other question is whether or not, if it was extended beyond something unreasonable, where based upon what he had, if that wasn't enough for him to either dispel or confirm his suspicions that something was going on based upon his interaction with her. And 8 minutes is not unreasonable. I understand that I'm sorry, I didn't even realize that, but may I continue, please?
Yes, you may.
I understand that taken in isolation, each one of those things is not sufficient. But when you couple it all together from his reasonable perspective, he had reasonable suspicion. That's not the way most people stop. In and of itself, no, that's not enough. But that is the first thing that got his attention. Her excessive nervousness that he observed. Yet again, I understand that the videotape did not reflect that. There's no reason to discount that, and there's no evidence contrary to that. At one point, he said to her, you were nervous, and she doesn't dispute it. That, and after he employed that technique to calm her down, and she still is not calm, those are reasonable suspicions, and it's sufficient for him to extend that stop for that K-9, which is already on scene.
The record, it shows that when he said, okay, he says, your driver's license, okay, she said, that's fine. I'm gonna check this out. If all this checks out, then I'm gonna give you a warning thing. And he walked off. He walked off.
He says if everything checks out, but it had not checked out at that point.
But he walked off when he said that. He went, I'm gonna go back to check it out.
Yes, and as he
But how did he, after that, before that, then confirm that it had not subsided, her nervousness?
Her nervous tapping on the door, which is
But he walked away when he said, I'm going to go check it out. The
Yes.
last thing he said was, I'm going to go check this out and be on your way if everything checks out. He walked off. So when he left,
yes, he left to
turned
go.
his back and went to cruising.
Yes, and from his cruiser at his car, he's watching her, and he sees her utilizing the nervous tapping on the door.
From his cruising, he said that's when he heard the tapping on the door.
He saw it, and you can see it on the video. You can see her tapping, and you can certainly hear him talking to the other officer, training him about this is a nervous indicator. So yes, after he tried to dispel her.
The inside of his car when he was talking. I mean,
Yes, I'm sorry. He was in his car.
and he could see her tapping inside his car.
She was tapping on the outside.
I know on the outside. Okay.
Yes, she's tapping on the outside of the door. So he's in his car. Her hand is on the outside of the car door tapping. Her hand's on the inside. It's on the outside of the car. And it was observable.
So she's exposing her hand, which is really good for police officers, because that's one of the best things to do, I would think, to make sure the police officers know, because so many times I saw them moving inside. Her hand is outside, so she's being even more so, wouldn't it? That's more than necessary because you got your hand out there and it's dangling and you're tapping. I mean,
No, tapping.
that's the opposite of being, you're trying to cover up something. You got your hand out so it can be seen. Matter of fact, I think one of the safest things to do is way it is now, keep from, being problem is putting both hands outside of the door. So you can't say, I'm not doing anything, grabbing for something. So that's a part of the reason to stop her, because she had her hand dangling outside so an officer could see it.
That wasn't why she was doing it though. It was
because she was dangling it because she's nervous and therefore. Okay, I see your argument now. I understand. Go ahead. I think your time is up, but you want to finish your thought on that?
The point that I was going to make, Your Honor, is there's no evidence in the record that she was tapping on the door for any reason other than potential nervousness, and not because she was somehow frightened or in fear of her life and she felt the need to let the officer know that she wasn't a threat. Thank you for your time.
Thank you.
A few points briefly, Your Honors. First, when the officer asked, this is at 12:01 on the body camera video, when it says, "You seem nervous," I actually disagree that she doesn't dispute. I think she makes a less than clear statement, but I think if the court watches that at 12:01, she'll say, she makes a face like this and annoyed. She goes, like, not really. She's not agreeing, I don't believe. Secondly, when she says, "Not that I know of," I just want to point out that both of those things occur after the stop had already been extended. The purpose of the stop was concluded, the district court found, at 11:59 when the citation was printed. You can hear that being printed off. It's printed. All that remains to be done is to hand it to the officer. And it's notable that hand it to the driver. The officer doesn't actually hand it to her until 12:53, which is nearly an hour after he pulls this car over and rummages through it over and over again, expressing his disappointment that he hasn't found any drugs, because this is, of course, a drug investigation. And when you are a hammer, everything looks like a nail. That being said, Rodriguez tells us two things that are relevant here. First, not even de minimis delays are acceptable, which is what we have here. And second, officer safety concerns apply only to the actual stop itself and not to the unrelated extended bonus drug investigation that was being conducted. And lastly, I did not hear the government cite a single decision of this court upholding reasonable suspicion on such thin facts. It falls well short of any we've found, and apparently not that the district court could find either. Only the suggestion that if an officer simply testifies that in his experience this is unusually nervous, that can somehow trump this court's precedent. It cannot, it does not. And for all these reasons, we ask this court to vacate and reverse. Thank you.
Thank you both, counsel, for your arguments. Love to come down and greet you. Yeah, we can't do that today, but know that we appreciate your arguments, and thank you so much for your representation today. Please be careful and be safe. We'll proceed to our last case. Ms. Blair, can you hear me?
Yes, I can.
Good. Everything you can see well, and the sound is good. Good. Yeah, you can mute yourself now until the time, but thank you so much.
Thank you.
Winograd?
Thank you, Your Honor, and may it please the court. We raised two arguments in this case, one substantive and one procedural. At the outset, I just wanted to address how those arguments fit together and whether the court needs to reach both arguments. The substantive argument, of course, is that my client was not convicted of a crime involving moral turpitude or CIMT. In many cases, whether a crime involves moral turpitude is a threshold jurisdictional question that the court must reach first. But in this case, the jurisdictional bar does not apply because my client was not actually charged with removability for having been convicted of a CIMT. So if the court prefers, it could instead reach our procedural argument first, which is that the board should have referred the case to a 3-member panel. Now, whether the court needs to resolve both arguments depends on which argument it addresses first. If the court resolves the substantive argument first, the procedural argument would become moot because there would be nothing more for the board to decide on remand. Likewise, if the court starts with and agrees with our procedural argument, it would not need to reach the substantive argument. By contrast, if the court starts with and rejects our procedural argument, it would then also need to reach the substantive argument. So with that being said, unless the court prefers otherwise, I will start by addressing the substantive argument. Now, the board in this case found that the statute was a CIMT for one and only one reason. It states that defendants must have an intent to defraud. But under the categorical approach, the question is not simply what the text of the statute says, but how that statute has been applied by state appellate courts. So the true question before this court is whether the intent that Virginia prosecutors must establish to obtain a conviction is the same as the intent that the board has long used as a test for moral turpitude. Now, in the CIMT context, the board has long held that an intent to defraud requires an intent to deprive the victim of his or her property. Now, that intent is similar to what this court requires for wire fraud, which is the intent to cause harm by depriving another of something of value. So in short, an intent to defraud, yes.
Case that requires that where the intent to defraud is a named element of the crime in the underlying statute.
I'm not familiar of any case involving the argument that we're raising, where an intent to defraud is a named element, but the argument is that state appellate courts have interpreted that language so as not to require an intent to defraud for federal purposes. I'm not aware of any such case, but there is a case that we cite in our briefs called Mungro, where similarly this court found that the North Carolina Supreme Court's interpretation of its burglary statute was actually much narrower than the text would seem to suggest. But the point simply is that an intent to defraud does not simply require an intent to deceive, but an intent to cause harm through deception. Now, by contrast, in upholding my client's conviction, the Virginia Court of Appeals did not require prosecutors to show that he actually intended to deprive the bank of its money. The court found an intent to defraud simply because he used a social security number that did not belong to him. And its decision makes clear that the statute would have been violated even assuming that the loan was fully repaid. Now, so by analogy, imagine a person obtains a rental car using someone else's driver's license, but they return the car by the required time and date. That person may have deceived the rental car company, but he did not defraud the rental car company. And so too here, as applied by the Virginia Court of Appeals, the statute requires an intent to deceive rather than an intent to defraud. And in this court's decision in Nunez-Vasquez, it held that an intent to deceive standing alone is not sufficient for a crime to involve moral turpitude when you're dealing with a private person or entity, as we have here.
So did the Virginia court actually say that the intent to repay is irrelevant on the question of intent to defraud?
Its analysis is in a separate part of the decision, but the decision separately makes clear that it is irrelevant whether the bank was repaid. And that's the part of the decision dealing with loss. And in that part, it actually found that there was no evidence that the loan was not fully repaid. And then in footnote 8 of the decision, it makes clear that the statute would be violated by someone who used a false social security number, even if they did fully repay the loan. But so to answer your question, it was not in the section of the decision involving an intent to defraud, but the decision as a whole, I think makes clear that the statute would be violated even if the loan was fully repaid. So our view is that the statute in this case is very similar to statutes that the board has held in other cases not to involve moral turpitude. So the board has held, for example, that writing a check with insufficient funds is not a CIMT if the perpetrator intended to replenish the account before the check was cashed. It has also held that obtaining goods. Yes.
Distinguishing factor in all these cases that you cited is that the underlying statute, unlike the one in this case, does not have the intent to defraud as an enumerated element of the crime in the statute.
I don't believe that's correct, Your Honor. In one of those cases, matter of Bailey, that was the case involving the Kansas statute, and that statute did include the words intent to defraud. And the board said that the way it was used in the Kansas statute was a term of art that was distinct from the intent to cheat or deprive a person of his property. So that is a case where the board has found a statute not to be ICIMT, even though the text of the statute included the words intent to defraud. And the other case I was saying, it's a matter of Kinney that involved obtaining goods under false pretenses, which is very similar to what happened here. And the board found that that was not a CIMT because perpetrators could violate the statute even if they intended to ultimately pay for the goods. So we think the logic of those decisions suggests that providing false identifying information to obtain a loan does not require an intent to defraud if the perpetrator can ultimately intend to repay the loan. And again, my client's conviction, in our view, was upheld in the absence of any evidence that he intended to deprive or did in fact deprive the bank of its property. Now, even if the court agrees with my argument involving the intent to defraud, the question does still remain whether the minimum conduct punishable under the statute involves moral turpitude. And again, we think the decision of the Virginia Court of Appeals in my client's own case demonstrates that it does not. The decision makes clear that yes.
I've looked back through matter of Bailey, and I'm not seeing where the intent to defraud was an enumerated element in the underlying statute.
I'm looking at the original reported version. The text of the statute is laid out at the bottom of page 679. It's quite a long statute, and it's in the second paragraph of that statute. And then the reference to the discussion of it is I believe on page 680, the board's discussion where it talks about it being, I'm sorry, my apologies, on page 681. And the board says the term intent to defraud as used in the section is a term of art which refers not to a proof of an intent to cheat, but to mere proof that a check was drawn with knowledge of the non-existence of the funds to pay it. So as I was saying, the Virginia Court of Appeals decision in this case, we read it to make clear that a person can be prosecuted for making up a social security number that they did not know belongs to another person, even if the bank did not rely on that number. And again, even if the bank did not lose any money because of the loan. Now, we do recognize that unlike the statute at issue in Nunez-Vasquez, the statute in this case does require the identifying information to belong to an actual person as opposed to a fictitious person. But we don't think that distinction is meaningful because, again, there is no requirement that the defendant actually know that the number belongs to another person. And as importantly, in Nunez-Vasquez, this court cited my client's own case as an example, seemingly as an example of conduct that did not involve moral turpitude. And we don't see why Nunez-Vasquez would have cited my client's case, Salazar, if it believed that my client's own conduct did involve moral turpitude. We also recognize that there is another distinction insofar that for a felony violation, some party does have to incur a financial loss. But in addition to being unintentional, the loss can include voluntary expenditures by the victim. So in this case, for example, the victim was only found to have suffered a financial loss because he signed up for a credit monitoring service after he started receiving correspondence in my client's name. And those type of expenditures typically are not even subject to restitution, much less direct criminal liability. So again, by analogy, consider a case in which a thief committed petty larceny by stealing something of minimal value, say a garden gnome, from a person's front yard. And then in response, the victim installed a very expensive security system in hopes of catching the thief if he returned to steal something else. In that scenario, it would be very odd for a jurisdiction to charge the thief with grand larceny rather than petty larceny based on the value of the security system. But that is effectively the regime that is in place for this specific statute. Again, the financial loss in my client's case only resulted because the victim spent money on a product of his own accord. And we believe that harm should not be sufficient to turn a statute that would otherwise not be a CIMT into a CIMT. And then finally, even if the court thinks that my client's own conduct did involve moral turpitude, we think the plain text of the statute would apply to someone who used a social security number simply to obtain a job. And multiple circuits and the board itself have found that that conduct, violation of that federal statute, is not a CIMT. Now, for its part, the theme underlying the government's argument.
Can I ask you about
Yes.
that? So how does obtaining a job fall under the definition of goods, services, et cetera, that the statute seems to require?
Well, we believe it would be to obtain money. Sorry. If I could return to that on rebuttal, Your Honor.
Sure.
But in any event, I mean, our primary argument is that the decision in Salazar itself makes clear that the statute does not involve moral turpitude. The government, for its part, seems to argue that the court should find the statute to be a CIMT because of the overall consequences of identity theft on society at large. But this court and the board have never adopted that type of approach. As an example, the board has long held that driving under the influence, simple driving under the influence, is not a CIMT. And this court held in Cabrera that participation in a criminal street gang is not a CIMT. Now, no one could dispute that driving under the influence or participating in a criminal street gang is harmful to society at large, just as no one could dispute that identity theft is harmful to society at large. But under the categorical approach, we do not look to the combined effect of all violations of a statute. We look at the minimum conduct that is required for any one violation of the statute. And for the reason we've explained, unwittingly providing another person's social security number to obtain a loan that one fully intends to repay and does in fact repay, we would submit is not sufficient to find that a crime involves moral turpitude. If the court has no further questions about the substantive claim, the procedural argument is simply that the board was required under its own regulations to refer the case to a 3-member panel. The regulations allow a single member to decide a case in a brief order, but require referral to a 3-member panel in any case involving a novel or complex issue. And the board's decision in this case was not brief. I see I'm out of time. If I could just finish that thought. And courts have repeatedly noted that whether an offense qualifies as a CIMT under the categorical approach is invariably complex. Thank you.
Thank you. Ms. Blair.
May it please the court, your honors. My name is Robin Blaya. I represent the Attorney General in this matter. Just beforehand, I'd like to thank the court for letting me appear by video. In this case, the statute specifically refers that under which Mr. Salazar was convicted specifically refers to with the intent to defraud. And he used someone's identifying information, which is discussed in Section C of the statute, which includes all sorts of personally identifiable information. He used that on a mortgage application, and I note that social security numbers are rarely listed anymore because of the fear of them being stolen or anything like that. You hardly ever see one fully indicated. Oftentimes they're either totally blacked out or by some sort of means, or they're only partially provided. The board properly considered how the courts considered this statute and have interpreted this specific statute. The plaintiff or the petitioner in this case did not have to know that the number belonged to somebody else. And the Salazar court noted in its decision specifically that it was undisputed that Salazar intentionally filled out and submitted a loan application using a social security number that was not his. There is no innocent explanation for such an action. This fact alone was sufficient to allow a reasonable fact finder to conclude beyond a reasonable doubt that Salazar had the intent to defraud the lender when he used the victim's social security number on the loan application. And subsections D, E, and F all refer to losses. And Mr. Salazar was found to have caused a loss to the actual social security number holder, Mr. Childers, I think was his last name. The fact that he's trying to argue this is deceit, the statute is explicit about defraud. The Virginia cases that have discussed this provision, and we cite to Taylor versus Commonwealth, I believe is the name of it, all indicated fraud was required. That in Salazar would indicate fraud is required to be convicted under this statute, not deceit. The Supreme Court has said that statutes involving fraud are crimes involving moral turpitude, and the agency properly permitted this cancellation application. This is a pretty much simple CIMT type case, and it did not warrant a 3-member panel to discuss this, especially when it had the Salazar case before it that indicated the various what needed to be showed. It indicated intent was the intent that was required, and that was to defraud specifically. So we think that the court should deny the petition for review. If there are no questions.
Thank you, Ms. Blair.
Thank you.
Right, you some response? I mean, well, anything else to add or anything further? Go ahead.
I just want to address Judge Diaz's question. The current version of the statute refers to a person who obtains money, credit, loans, goods, or services through the use of identifying information of such other person. So our argument would be that using a false social security number to obtain a job would be an attempt to obtain money. I am not certain that money language was included in the statute when my client violated the statute. I will certainly clarify with the court through a 28J letter.
Well, I guess even if it's true, I mean, the question is whether or not there's a realistic probability that the Virginia courts would apply the statute in that way, and you don't have a case.
We don't have a case, but this court held in Gordon v. Barr that a case isn't required when the plain text of a statute makes clear that a statute could apply to certain conduct. So we would be relying on the plain text here rather than an actual case. So at this point, we're not aware of any actual cases.
Right.
Unless the court has further questions about the CIMT issue, just to return very briefly to the procedural argument, at the time that the board issues a decision, it of course has no way of knowing whether it will result in a petition for review, much less whether a case will go to oral argument. That being said, the fact that so few cases go to oral argument, particularly in this court, the fact that the court found that this case was sufficiently complex or worthy of oral argument, I think is a sign that the board at a minimum should have referred the case to a 3-member panel rather than a single member. Likewise, if there is any division on the court as to whether the crime involves moral turpitude, I think that itself would counsel a remand for consideration by a 3-member panel.
I guess the problem, though, is even if we had some qualms about that, how do we have jurisdiction to review something like that given that the regulations don't suggest that a failure to comply with that edict provides any procedural or substantive right on the part of a petitioner.
Oh, because this court held in Quinteros Mendoza.
But that was before the regulation was changed, no?
I don't believe it was. I will double check that. I don't believe it was. And I think the court's analysis, likewise, I think just kind of rejects the premise of that argument. If I recall, I believe the Third Circuit specifically rejected that argument in Provigan, which was a case decided in 2006 before, seeming to indicate that the regulation was in place at that point. And it squarely rejected that argument, saying that the fact that an agency may not have intended for its decision to be subject to review has no impact on whether a court actually has jurisdiction to review it.
All right. Thank you.
Thank you.
Thank you, counsel, both, and we appreciate your participation, and we can't come and greet you. We wouldn't be able to do it virtually anyway. Before the pandemic, you say sometime we should come by and high five the screen. So we're going to shoot at it as well today. But thank you so much, and I wish you well and be safe. Thank you so much. With that, I ask the clerk to adjourn the court. Sine die.
This honorable court stands adjourned. Sine die. God save the United States and this